May it please the Court, I'm Tom Phillips, and Mr. Devlin and I represent the appellant in this case, Mrs. Anders. Dean Corbin Anders died on May 3rd, 2012 as a result of a collision between his pickup truck and an ambulance being operated by Justin Matthew Kidd. At the time of this collision, Mr. Kidd was transporting a patient to Lynchburg General Hospital. He was doing this on a non-emergency basis without activating lights or sirens. He was charged, his sole responsibility was to drive the vehicle efficiently and safely to get to the hospital by the most direct route. Another person was in the back with the patient. That individual was the attendant in charge, and there's no controversy that he was the one who was responsible for all patient care. Mr. Kidd was charged with transporting them because they were operating on a non-emergency basis. Their protocol required them to obey all traffic signals. The evidence in this case was assumed in the briefs and for purposes of the argument before the trial judge was that when he reached an intersection in the city of Lynchburg, Mr. Kidd ran through a red light and struck Mr. Anders' vehicle broadside in the intersection. The issue as it was presented to the judge is whether under the circumstances of this case, Mr. Kidd was entitled to sovereign immunity for all acts of negligence which he committed while transporting the patient. And this issue was addressed squarely in front of the judge. There's a discussion between the judge and Mr. Harrington that's referred to in the briefs, where the judge asked, well, Mr. Harrington, is it your position that a driver should always be immune anytime he's transporting a patient? And Mr. Harrington responded, absolutely, yes. If he's transporting a patient, then he has to make certain decisions, and that's enough to entitle him to the protection of
Counsel, could you pull that mic to you just a little bit?
Yes,
Thank
ma'am.
you.
I'm afraid I'm going to have a coughing spasm as well. I'll try to speak up. I apologize for my voice.
Thank you.
But
you ought to know, too, that mic is not for the purpose of amplifying your voice. It's for the purpose of recording your voice.
Oh, well, then
yes.
it won't
you need
help.
to
I
speak
didn't
up.
know that, Counsel.
It doesn't.
Yes, sir. Well, I feel better since Justice Powell was unaware of that as well. I will try to speak up. The issue then became one of whether the proper focus in deciding whether immunity applies to this case should be on the act which is alleged to be negligent, the act which produced the harm, or the status of the actor at the time the act occurs. And it was their position in the trial court, and it's their position now, that the prior decisions of this court clearly show that the focus needs to be on the act itself. You look at the act. That's why this court time and time again has said these are fact-specific cases. They require the drawing of lines. And it's why this court in Friday's Spivey said that we are rejecting a request that we create a blanket immunity for operators of specialized equipment anytime that vehicle is being used for a governmental purpose. This court rejected that argument and instead said, no, we look at the nexus between the judgment and discretion that the person is required to operate and the harm which resulted. And in this case, the court concluded that there was no nexus between the special nature of the equipment or the task that the defendant was engaged in.
Counsel, let me interrupt you and ask you a question.
Yes.
And this is not your case, but I just would like to have your thoughts about it.
Mm-hmm.
Assume that the ambulance driver here had decided that it was an emergency, that he needed to transport in that sort of status as opposed to the non-emergency status. I take it you would not be arguing then that he was not entitled to sovereign immunity. You would acknowledge that he was.
If he, in his judgment, had felt that it was an emergency, and if he had activated his lights, then I do not think that the plaintiff could second-guess his decision in deciding that he was required to do things he's allowed to do with his lights on, like go through a red traffic signal. or like take a detour onto a shoulder, if he, in his judgment, had decided that in order to take care of his patient, he was required to drive faster than the speed limit, and the harm resulted from the speed of his vehicle, then I concede that sovereign immunity would be appropriate.
Okay, let me step back a minute, because the reason I'm asking you that is it seems to me what I hear you saying is that as a trial court, now as an appellate court, that a court then should not, in any situation, I guess, second guess or take a look at whether the decision that was made, for example, this case, to transport on a non-emergency basis, or if the decision had been just the opposite, to transport on an emergency basis, that we shouldn't, in the analysis of sovereign immunity, look at that decision and the validity of that decision. That we should take, however the defendant viewed the situation, and go with it.
Not necessarily, Your Honor. I think what we should focus on, first of all, is what was the act which caused the injury to occur. And then we should see if there's a nexus or causal connection between that act and something that the governmental employee believed, in his judgment, was necessary for him to do in order to fulfill the governmental task. And that's
so we go with the subjective decision of the governmental employee about whether there's an emergency or not?
Certainly you would be closer to the idea of whether or not it's something where he has to make a split-second prompt decision, to use the language from your dissent in the Friday's Spivey case, because of the exigencies of the circumstances. Certainly that's one of the things that I think the trial court would need to consider, is whether he was reasonable in doing that. I don't think it would make any difference if he thought it was an emergency and he was running with lights and siren, if the reason that he hurt someone was he was texting his girlfriend. It's not just that he has the lights on, it's that he does something because he has concluded that he has to do it, even though it entails an additional or special risk. He has to do it to protect the patient and to fulfill his task.
Why isn't there always a special risk at issue when you're transporting a patient in an ambulance? Whether the driver or the medical technician has made the decision that it's an emergency or not an emergency, why isn't that always some special risk as opposed to driving the ambulance to fill it up with gas?
Judge, you are in a position where it is always possible that you might be called upon to make a decision because there's a patient on board. If, in fact, something happens, the patient's condition changes, if there's a disturbance in the ambulance. But those things didn't happen in this case. If those things had happened, then there would be a distinction. There would be a distinction if, for whatever reason, staffing problems or whatever reason, you're alone. You are the only person in the ambulance and there's somebody in the back and you are trying to multitask and divide your attention. Then you'd be like the school bus driver in Linhart. But that's not the case here. In this case, there actually is another person charged with taking care of the patient. As far back, Your Honor, as in Hyder versus Clemens, this court told us, and I quote, "The defense of sovereign immunity applies only to acts of judgment and discretion which are necessary to the performance of the governmental function itself." And I would submit the focus has to be on the act, not on the status. If the status
the act here is transporting a patient. In the two school bus cases, if our memory calls me correctly, we granted sovereign immunity where the driver, there were children in the bus, and we didn't when there weren't any children.
You did, Your Honor, and in that case, as I pointed out, the appellees argued that they should be given sovereign immunity because he was, not only was he charged with driving, but he also was charged with monitoring and taking care of the 3 special needs children who were on his bus. So in that case, as opposed to this one, we have an employee who is charged by his employer with doing 2 things, 2 tasks, watching, monitoring, and protecting children as well as driving. In this case, all Mr. Kidd was charged with doing is safely operating the vehicle.
No, it's a little more than that. He was charged with transporting this patient. He wasn't just driving. He was transporting somebody who obviously needed medical care. So why shouldn't that be what we focus on and not whether, in his judgment, he thought it was or wasn't an emergency transport?
I would respectfully submit, Your Honor, that what happens in that case is we are extending blanket immunity to operators of certain types of vehicle based on their status, based on their position, rather than looking to see whether there was any connection between any special obligations he had because he had a patient on board and the fact that the accident occurred. And in this case, there simply is no connection. There's no allegation that he was distracted by his patient or that he, in fact, was looking and doing something other than driving. He doesn't even claim he decided to run the light. It's a simple case of inattention. It could have happened in any other vehicle. There is no nexus between the fact that he was driving an ambulance or that he had a patient on board and the fact that this collision occurred.
So what you're saying, sovereign immunity would only attach if he had said, I needed to run this red light because I needed to get this person there quickly.
Yes, ma'am. I'm saying if he said that in my judgment and discretion this was necessary, if he had said I drove on the shoulder because in my judgment and discretion it was necessary, then I would say sovereign immunity would be appropriate.
Doesn't that mean that every... Go ahead.
No, I think you asked the same question.
Doesn't that mean that we're going to let the defendant, be it the ambulance driver or the fire truck driver or the police officer, whatever his subjective decision is, control whether sovereign immunity is available to him or not?
Well, Judge, I think certainly in the case where he concedes that it was not a decision he was forced to make, I think this Court has said in deciding when police officers are entitled to immunity and when they're not, that it's important for us to consider what actually was happening and caused the collision or the accident to occur. If what the Court's saying, if just the fact you're transporting a patient is true, then every police officer on duty, every minute, would be entitled to sovereign immunity because, in fact, they are always charged with keeping a lookout, being aware of what's going on, and at any second they might be required to make life or death, shoot or don't shoot decisions. And that just hasn't been the law. We've only granted immunity, this Court has only granted immunity when the very action which resulted in the harm was something that was done in order to necessarily done to fulfill the governmental purpose. If I could reserve my final 2 minutes. Thank you.
If it may please the Court, my name is Bob Harrington, and I represent the appellee Justin Kidd. Justin Kidd was transporting a very sick individual with a lot of various medical complaints, and that's all through the record. She had chest pain of 9 or 10 pulsing side of her chest. She has a very complex history of bipolar disorder disease, anxiety, depression. She gives a history that she's taken alcohol that day. She's having problems with the medications. So Justin Kidd, who is the paramedic, he is the highest level on this transport. The person in the back, Mr. Campbell, is an EMT intermediate, so he's a lower level of care. The testimony was that this is an advanced life support transport. This is the highest transport that they perform. There's advanced, and there's what they call BLS, which is a basic life support, and that is what they are doing. They are transporting. He has exercised judgment and discretion in how he's going to transport, when he's going to transport, if he's going to transport. And not only that, throughout the transport, there's testimony that he's monitoring the situation in the back. He's looking in the mirror. He's watching what's occurring. He's concerned about the safety not only of his fellow EMT, but also he's concerned about her condition, watching her condition. He does not activate the lights and sirens, admittedly. He testified that of 90 to 95% of the calls, they do not activate lights and sirens. Having done this work since the mid-90s, I know why that is. Because cars respond in the most odd ways to rescue squad vehicles when they put lights and sirens, not knowing whether to go right, left, and cause a lot of accidents. The only time under their protocols, that they activate lights and sirens is when there's an immediate threat of death. There's something that is so immediate that they need to get to that hospital immediately.
Let me ask you a question about protocol. Why should an individual locality's protocol resolve this matter? You have the potential of a different protocol in multiple counties and cities all over the Commonwealth. They're all EMTs and first responders. They're all driving ambulances. Why would somebody in Norfolk be treated differently than somebody in Alexandria simply because an interdepartmental protocol reads differently?
I don't think you do. In fact, this protocol could have easily said in every transport beyond a certain minimal level, you activate your lights and sirens. The decision has never been whether the flip of the switch is required to activate lights and sirens. So you could have in Norfolk a protocol that says lights and sirens, but I don't think legally that's what the standard is. The standard is, again, looking at what exercising of judgment and discretion that person in that situation.
Your position is an objectively reasonable decision by the first responder.
I think objectively decision in looking at all the facts of this court as to what was occurring, yes. He could have easily have engaged lights and sirens. He could have run every red light. He could have done all of that, but that would have been not safe.
So, counsel, do you now not take the position that if you have a patient on board, you get sovereign immunity as a blanket proposition?
I would answer it the same way I did at the trial court level. When you have a patient on board, and this court has never dealt with this decision, and this factual type of pattern is I'm aware. When you have a patient on board, just like the children on the bus in the Linhart case, you look at those cases, the earlier case, there was nobody on the bus, and they were returning from the filling station, which shows you the age of the case. They're returning from the filling station, and the bus driver pulls in. The kids are all in anticipation. But the second case, they're on the bus.
Counsel, you might be making it a little bit more complicated than I asked. I'm going to ask again. Do you get sovereign immunity because you have a patient on board?
I believe yes.
Okay.
And the reason being is even if I've cut my finger or cut my hand and I'm on board, patient can change. They still have to monitor. They still have to react to every other vehicle that reacts to them as an ambulance coming down the road. It's not the coming back from the filling station.
Can I ask you a question? Don't they have to react to them even if nobody's in there? I mean, even if nobody's in the ambulance, people are going to react the same way on the street to a guy driving an ambulance.
Legally, they don't have to react because the statute says if you have lights and sirens, then you have to move over.
But you're not talking about legal reactions. You're talking about reactions of a guy just driving an ambulance down the road.
And I'm getting to that too, yes.
Yeah, so why does it matter whether somebody's in the back or not?
Because that patient's status could change quickly. If I'm the type of person who I look at blood and all of a sudden I hyperventilate or I pass out, they monitor. He is monitoring that patient along with the person in the back.
Okay, so counsel, we also, whatever we do in terms of sovereign immunity, it's not going to be with regard to just EMCs or whatever. Based upon the answer you just gave, I'm going to presume you would also say there should be blanket immunity for police officers when they're responding to a call, firemen, firefighters when they are responding to a call, or anyone else involved in public safety or patient care. Would that be a safe statement?
I think you have to look at the facts of those other situations, just like in the deputy sheriff who's serving process. He serves process, he finishes, he's heading back to the station. You still have to look at the facts. What I'm arguing in this situation is when you have a patient with active medical care, and you have all this standard of care issues, and you have the transport issues, while that driver is going down the road, he's making decisions constantly about what route they're going to take. If the patient has a problem, they can go to a near medical provider. They can go to a doctor. They can go to a different hospital. They can call in medical transport. It's a different situation.
Again, the complexity of your answer is causing me to get a little bit confused because I'm not as quick as you are. That's all right. Let me, if in fact we disagree with you that you get blanket immunity every time you have a patient, we then have to draw a line. if we drew a line saying, did the driver reasonably believe that this particular action was necessary to benefit his passenger, his patient, would your client have fallen on the sovereign immunity side of that line?
I'm having a little difficulty with the question because blanket, I think, is not the word that I would use.
It's the word I use because there's no situation where you've got a patient where sovereign immunity wouldn't apply.
With a patient, with active care, I believe that.
Okay, I'll call that blanket for shorthand. Okay, if we disagree with blanket sovereign immunity, as you have just expressed it, and we were trying to come up with a test, and we said, did the driver reasonably believe that this particular act, i.e. going through a red light, was necessary for his passenger's care, would your client have fallen on the sovereign immunity side of that line?
I'm still having a difficult time, but I'm going to try to answer it the best I can, because I don't believe it's an accurate statement of what is occurring here. In other words, yes, there's an allegation that he goes through a red light. But at that point, he is engaged in the care and transport of the patient.
Did he reasonably believe it was necessary to go through the red light for the benefit of his patient?
No, I don't believe it. In other words...
It wasn't necessary for him to go to the red light.
No, because to do that, he would have activated lights and sirens.
Okay.
That's the only thing.
You've answered my question.
But he believes he was going through a green light, so that's why I'm having a difficult time with it. And the discussion is to, let's talk about traffic, obeyance of traffic signals. If that were the standard, certainly, obviously they could put the lights and sirens on, but that is not the standard in all the sovereign immunity cases that this court has held previously, because you have the bus cases. And clearly that Linhart bus case, the person driving the bus has the obligation to obey every traffic signal. You have the Hilton case.
Counsel, let me ask about what Justice Mims calls the blanket immunity. You mentioned a patient with a cut finger. Obviously, they're not bleeding out. There's nothing else going on. They have a cut finger. Apparently, in this area of the state, they're going to take the medical transport because they don't have transportation. No leads hooked up to them, no complications of past medical issues, no alcohol, none of the background that this patient had. Does that driver get immunity?
Well, answer two ways. Yes, I believe so, because if you go to the Linhart case, there was no discussion as to whether the children were acting up, whether they were impacting the driver at all. The fact that the children were on the bus made a difference from the prior bus case. In this case, the patient is on the bus.
And so your answer would be, we rule that way in Linhart, we have to rule that way here.
I believe
children
so.
Versus patients.
And the second part of it to answer is, then if you look at the facts of this case, we have something very different. So you have an option of one, now I'm using the word blanket, but to make that kind of blanket distinction, or two, to rule upon these facts.
If we were trying to draw a line, would it make sense in your mind to draw a line when the patient does start to deteriorate, or the guy in the back says she's starting to code, we need to get there now? Would it make a difference that at that point the driver is making discretion whether to go full speed ahead through red lights?
I don't believe that you can do that type of sliding scale, because where do you draw the line? And then imagine the type of evidence, imagine what would be occurring in the minds of these drivers. I don't think you can do that. I think medical care is medical care, monitoring a patient, making decisions as to what facility to take this person to, watching to see the condition and the care that's being occurred, getting ready, if necessary, to go in the back. He testified, Mr. Kidd, that if her condition worsened at all, he would then have to switch with the other driver because he was the higher level of care. Paramedic being the highest level of care that they can obtain. So if you look at all of the cases, this is very different than a Friday Spivey. Factually, Friday Spivey is the person driving the ambulance, not the ambulance, but the fire truck, the equipment, and the personnel to a call. They don't know the extent of the call. Here we have an active call that's occurring, being transported, so it's very different.
There was an active call on Friday Spivey.
It was an active
And
call.
it seems like the court's decision turned on the fact that by policy it could not be treated as an emergency response, and the driver acknowledged that.
And I agree. The facts of that case, there was some testimony that was very bad for the driver in that I think there was something about them finishing their lunch, they take their time. There was some testimony about a cat and whether they would have responded the same way if it was a cat in a tree. That's very different than this call, which is advanced life support, the highest level call, as they're transporting a patient who's very sick with a very complex medical history.
I thought this one was a BLS, once they got there and determined that.
No, I believe it was an
This
ALS.
was an ALS?
Yeah, and I cited the transcript to it, but it was an advanced life support with that kind of history. In fact, the call that they responded to really wasn't, I don't think, even as severe as when they got there and took all the history and the alcohol and the bipolar and the schizophrenia and the medication problems and everything. It was a very serious call.
Are you sure this was ALS after the pickup?
I believe
it was originally called in as such.
That is my memory of it.
Where in the record? Is there any place in the record that you're aware of that would establish that?
I had cited to the appendix at page 108. And I would even point out that I think even if it's an ALS call under their own protocols, there's still, BLS call, it is still the care, judgment, discretion that this person is exercising in the transport.
I'm concerned that you go back to this protocol. I just like to ask you about it. If you go back to the protocol every time, wouldn't the wise thing for a locality to do is to have a protocol that says everything is an emergency? It would insulate them from suit.
I have represented so many municipalities throughout this Commonwealth in these kind of cases, and their protocols are all over the place.
That's why I wonder why we go to them. Why don't we go to some reasonable standard, objectively reasonable standard of a person, a police officer, a bus driver, a fire truck driver, their reasonably objective standard, given the circumstances they're in, rather than going to protocols that might be different in 150 or 200 different localities across the Commonwealth.
But I think it still goes to one of those factors in the Messina case that talks about the control of the municipality over the individual. So the protocols show a certain level of control over those individuals as to how they're doing this act, how they're performing. But I do agree with you. I don't think you take protocols that could say everyone is an emergency and make that the standard. I agree with that.
Ralph, may I ask a question, Chief?
Yes.
I agree with you. 108 says it was an ALS call, but there was testimony from the driver that he faced an ordinary driving situation in routine traffic. He explained that because Lovejoy only wanted non-emergency transport, he was under a mandate to conform to all the usual rules of the road. There seems to be some conflict between the level of the call and what this witness is actually saying he was doing. Is that a fair read of that?
I have a couple of responses. One, routine being that nothing during the transport happens where she crashes. They have to go into an emergency situation where they have to either arrange for different...
So why wouldn't that be when the judgment kicks in? Something out of the ordinary has happened during this drive.
If that were the standard, then that's very troubling that you would have to be looking then for something out of the ordinary to occur. When they're monitoring, they're giving...
That's why they're monitoring.
They're giving, but that's the judgment discretion. He's exercising judgment discretion throughout the transport, in monitoring, in looking and checking to see what's occurring. And then the second part of that was, again, you look at the other cases, and it really is not a situation where it has to be not obeying traffic signals. In other words, again, even in the Helton case where the officer decides to pursue, and he decides to pursue somebody who makes a turn, he does nothing more than make that decision and then runs into the vehicle in front of him as he's getting ready to do anything.
But he's made a decision based on something that happened at that time. The driver who was driving normally suddenly decided to make an illegal turn.
But the judgment and discretion here is the decision to transport, how to transport, what route to take, that sort of thing.
Counsel, I see your reference to page 108, but when you move to pages 134 through 136, Mr. Campbell, who was in the back, said Mr. Andrews had no responsibility whatsoever for patient care. Other than driving the ambulance, what did Mr. Kidd do? I'm sorry, Mr. Kidd. What did Mr. Kidd do with respect to the patient in the back? And the answer was, as far as I know, nothing. He didn't. I was in charge of patient care. And then he goes on to say that the patient was stable, the patient was not a critical patient, and there is nothing in his answer that would cause one to believe, to conclude that it was still an ALS call. It was ALS when they were heading there, but once they established her condition, it was just simply, we need to have her checked out.
Yeah, I don't think that's consistent with the rest of the evidence in that they put an EKG on her because they were concerned about her heart.
Well,
she was concerned. So I think it stayed.
All of it came in with your questions on redirect, other than that very first one where he said that.
And I believe it stayed in ALS call under the evidence that's in the transcript.
Okay. Thank you. Counsel, you had about 2 minutes left, but we gave the police some additional time, so I'll give you an additional 3 minutes.
I don't think I need much
time.
Well,
you've got 5 minutes if you wanted.
Thank you, Your Honor. First of all, I would like to return to your questions earlier, Madam Chief Justice, about whether I was giving too much credence to the subjective state of mind of the governmental employee, and I would say that I think the answer is the one supplied by Mr. Justice Mills, that what we need to look for is an objectively reasonable belief that it's necessary to perform the act which produced the harm. So I wish I'd been quick enough to come up with the formulation that Justice Mims did, but I think that's the appropriate way to deal with it. To address Justice Lemon's concern about the protocol, I think the reason everyone was concerned about the protocol was because the allegation was specifically that there was failure to stop for a red light. I do think we have a statewide standard that applies there in 46-920, which allows emergency vehicles to run lights provided they are operating lights and sirens when they do it. So I think that in this particular case, even though the protocol corresponded with the statute would result in a uniform statewide standard controlling the particular act involved in this case. The last thing I would address is I would submit that this is a perfect example, a perfect time for the court to reiterate that we are not granting blanket immunity, that we want to draw lines on a case-by-case basis, and that there has to be a nexus, there has to be a causal connection between the act which produced the harm and the exercise of judgment and discretion necessary to complete the act. To the extent that the court feels that there is an inconsistency with Blenhart, I would respectfully point the court to this court's decisions back even before I started practicing law in Surratt versus Thompson and in Smith versus Kaufman, both of which were decided the same day in 1971. And in those two cases, this court abrogated interspousal immunity in automobile accident cases and parental immunity in automobile accident cases. And what this court said is and I'm quoting, former rules should give way to rules of reason in the light of changed circumstances. And this court said, given the fact that there is universal or near universal liability insurance coverage in automobile cases, in those limited circumstances, we are abrogating the old common law rule. And in making that ruling, this court said the genius of the common law is its ability to evolve, to change with time, to reflect new circumstances. in James versus Jane, when this court was considering whether to grant immunity to a doctor practicing at the University of Virginia. One of the things the court said is, we don't give as much weight as we might have in the past to the need to grant immunity to doctors practicing here, because it's inconceivable that any doctor in today's times would practice without medical malpractice insurance, whether they practice in a state hospital or not. I would respectfully submit that surely the same sort of considerations would be available here. Surely no ambulance crew, no rescue squad would send its drivers and its vehicles out onto the road without the protection of liability insurance. That doesn't answer the question, but it simply, to some extent, undercuts the historical necessity for providing immunity to employees involved in automobile accidents when they are engaged in this type of activity. We would respectfully submit that Judge Cook erred in granting the plea of sovereign immunity, would respectfully request this court to reverse his decision and to remand the case to the trial court for trial. Thank you.
Thank you.